All right, welcome back. You're still watching Morning Cafe with me, Fred Indimuli. We now switch gears from matters politics to legal matters, and today we want to discuss a bit of labor laws. Understanding unfair termination. What exactly does it mean? Would you even be able to recognize if you are unfairly terminated from your place of work? And to help us understand this morning, we have our usual legal expert, Wakili Silas Akiro. Karibu sana, Wakili.
Thank you very much, Fred. Good morning.
Good morning. It's good to have you in studio this morning.
Thank you very much.
So let's start from the beginning, because not many people do understand what exactly constitutes unfair termination under Kenyan labor law, because probably there are people who've worked in different jurisdictions. They come to Kenya and they do not understand. What exactly does the Kenyan law say on unfair termination?
Fred, first of all, we must understand that the Kenyan labor market actually trades on quite a number of pieces of legislation, but chief among them is the Employment Act 207. And this particular legislation governs how employers are supposed to handle their employees within the Republic of Kenya. Now, when you talk about unfair termination, or termination generally, is when your employment contract or your employment with a company, an organization, an employer ends. Mm-hmm. So this particular point of ending or terminating an employee's employment, there are certain procedures that must be followed. So if these procedures are not acutely or accurately followed, then that kind of termination is termed as unfair termination. Mm-hmm. It is a particular type of termination that jeopardizes the person. The person feels aggrieved that he has not been given a chance, proper chance to state his reasons why a certain occurrence that led to this termination took place. Mm-hmm. So if the procedure that we're going to look ahead here are not carefully followed, then the employer commits an offense, or rather an illegality known as unfair termination.
Okay.
Yes.
And then probably, if at all there is unfair termination, then there must be the legal or lawful way of dismissing an employee. Probably, if we can go there, what is really the difference? Is there, because we live in an age where we have casual workers at home, probably my nanny or the person we call the house manager. And when I want to dismiss them from work for one reason or another, what is a legal way of doing it?
Well, exactly. Fred, you know, when you talk about dismissal, it is sometimes used interchangeably with termination, mm-hmm. although they are not intertwined. Mm-hmm. We have circumstances under which an employee may be dismissed, and circumstances where now the employment contract is terminated. Now, when we talk about dismissal, we have summary dismissal and constructive dismissal. Now, when we talk about summary dismissal, this is where if an employee commits gross misconduct as stipulated under Section 42 of the Employment Act, or as stipulated within the employment contract. The contract of employment may stipulate circumstances under which, if you commit certain offenses within the employment period, then the employer will be able to summarily dismiss you. Mm-hmm. Now, summary dismissal is ending your employment without so many procedures, mm-hmm. or hurdles. The employer just tells you, because you've committed this as stipulated in the contract or as stipulated in the Employment Act, you are summarily dismissed. Mm-hmm. But when you talk about constructive dismissal, this is where neither the employer nor the employee sees a reason for your end of employment, but the employer either way pushes you to the corner to an extent that you either resign or you're put under very harsh working conditions that makes you to end, mm-hmm. your employment by yourself. So through this, there is some bit of influence, mm-hmm. by the employer from inducing certain illegalities within your acts or conduct within the employment environment. So as a result, you find the workplace untenable for you and you end up leaving. So this one could be called a constructive dismissal. But then when you talk about now termination or wrongful termination, unfair termination as we have discussed it, there are procedures that have been stipulated by the Employment Act. Number one, the termination has to be within the confines of the employment contract. And if the employment contract is coined in such a way that it contravenes the provisions of the Employment Act or the provisions of the Constitution, then those sections of the employment contract that contravenes the law becomes illegal. So first of all, they're chopped off. However, if the employment contract is perfectly coined, perfectly constructed or drafted, then it confines within the law. Then, number one, the bare minimums for the employers as stipulated by the Employment Act is that, number one, the employee has to be given a notice. And within this notice period, the employee has to be given a chance to be heard. And the chance to be heard could be either by representation. You can bring in somebody to represent you. For unionized employees, those who have unions, they are allowed to bring with them a representative of their union to listen in. Most employers do not love to have lawyers within the internal procedures of their processes. And so as such, the employers are always kept off until such a time when the termination is concluded, and now the lawyer has to take the issue to court. So if the employee has not been given a sufficient time to be heard, to state his reasons, and if the termination letter does not contain proper reasons for termination, then the whole process of termination is called unfair.
It will be unfair.
Yes.
But listening to you, because you talk about a contract, are we saying that this discussion, therefore, is only for those people who are in formal employment where they have a written down contract? Or does it also apply to situations where probably the contract was verbal? In situations like the domestic situation where you have a nanny or a house manager who does not have a written letter of appointment or a written down contract, then can they also claim unfair termination if the contract was verbal?
Exactly. The gist of this is an interlink between written and unwritten rules. But the law, that is the Employment Act, gives the employers the bare minimum. So just as you give the formal employees notice and sufficient grounds to be heard or to state their reasons, or even representation. You see, this is premised on the rationale that nobody should be condemned unheard, whether in the employment sector or general legal practice. Nobody should be condemned unheard. And so even the employees on informal employment, those casual laborers at home, the law actually applies to them. You need to provide them with, I know there are certain circumstances, for instance, where somebody is still on probation. Some employers or some lawyers have argued that you can terminate an employee on probation without notice. Well, that is the stipulation within the law. The courts have argued that if you terminate an employee on probation without notice or without proper giving them proper time to state their reasons, then you have committed what we call discrimination. Because whatever you do to the other employees, if you don't do them to this particular employee on probation, then you have discriminated against this employee. So just like those informal sectors, the bare minimums of the law is that at least give them reasons why you are terminating them. at least allow them to state a defense on their charges. At least make the termination in a way that is satisfactory to them. That when they read or anybody reads the termination letter, then somebody will say that truly, this person committed this offense.
So the culture where I wake up and tell my house manager, Wewe, I don't like your work, pack up and leave, and I'm giving you 1 hour. Is that sufficient notice? Because probably the arrangement between myself and this person was verbal, and they did not sign anywhere stipulating how much notice period should be considered. How does that work? Is there a basic minimum for notice period, even in such instances?
Well, for notices, the law always works with 28 days. That is 1 month. For some instances, like probationary employees, the law works with 7 days. For these other ones, then you can work between 7 to 21. At least 14 will be sufficient, or you can just give them 7. 7 days notice will be sufficient notice, because they do not have, your employment contract is verbal and does not stipulate what is the notice period. However, remember, Fred, that there are certain convertible verbal employments or casual employments. If the employee has worked for you continuously for a period of 1 month, then that kind of employment is convertible from casual to permanent and pensionable, where the normal benefits to a normal employee kicks in.
Even the casual worker?
Yes.
Even the farm worker?
Yes.
Many employers have no clue about this.
They don't know.
Are we saying that many may find themselves in court?
Certainly, that's what I'm arriving at. Because even many workers also are not aware that they can convert their employment from casual to permanent, where all the benefits, housing, commuter allowance, all those leave, annual leave, sick leave, paternity, maternity, all those compassionate leaves, they kick in.
Okay.
But these ones are normally reviewed by the courts when you take the case to court.
Okay.
If you do not, then it's like you're sitting on your rights and you shall be able to shoulder the liabilities.
Kelly, hold that thought there. Ignorance is no defense in a court of law, they say. Let's take a break right now. You're watching Morning Cafe. We'll be back to continue this conversation about unfair termination.
Vile unavyojua watoto wengi sana hawana namna. Mimi ningependelea watoto wasome.
I'm here to stress on education. At the same time, let us actually do any kind of sport that we are doing. Sport speaks the best language to everybody.
Tunataka tutafute talents. Zile raw talents kutoka kule nyumbani mashinani mahali tuko leo.
Hizi mbio za Chepsaita, like all other sports, zinaleta watu pamoja.
We want to use this event to uplift the lives of the community.
Anafurahia hii mchezo sana. Hata sikaange naambianga watu tuende Chepsaita.
Wanafunzi wakimbie ili wakuze talanta ya mbio ama kuhimiza tena elimu.
This is the place to be. Hapa ndipo mahali wanastahili kuwa tarehe 7. Wale watoto walikimbia last year, wamekimbia mpaka wamefuka mipaka zetu za Kenya.
Hey there, friends. Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism, how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through barriers from one story.
Welcome back. You're still watching Morning Cafe right here, TV 47. We continue with this conversation with Wakili Silas Sakiro on unfair termination of employment. And just before the break, you were talking about the notice period and how it varies. The other thing that I had you talk about too much, and even as we continue, I'd like to ask and direct our viewers that you can actually call in live to this conversation, make your contribution to it. Our call-in number is 0795 045 864. Once again, our call-in number is 0795 045 864. If you're unable to call, you can also send us a message on WhatsApp or ask a question with regard to this topic. Our WhatsApp number is 0793 267 279. WhatsApp number again, 0793 267 279. Wakili, now away from notices, you talked a lot about the reasons for termination. And are you saying that there are reasons that could be considered not legitimate for terminating someone in employment?
Exactly. Mm-hmm. Most employers would curtail their reasons to unsuitable for employment, mm-hmm. or zero performance or underperformance. You really need to substantiate, mm-hmm. these reasons. For instance, recently, or for the past, we have been having employers being agitated by employees who find love at workplace. Mm-hmm. And the recent finding of the court says that employers are now curtailed from preventing employees from mingling within the office setup.
So fraternizing with a colleague is no longer a legitimate reason for me to be terminated.
Exactly, exactly. You can just make away with your wife from your colleagues and the law will applaud you for that. Mm-hmm. So you find that there are so many flimsy reasons that employers give, or vague reasons. The reasons for terminations need to be very specific. When you talk about summary dismissal, these are now the proper reasons that are grounded within the law. Mm-hmm. Other reasons can be confined within the contract. But for summary dismissal, the law has taken it painstakingly upon itself to stipulate the reasons under which somebody can be summarily dismissed.
Which are these?
For instance, for gross misconduct, maybe you have been convicted of a crime for imprisonment of not less than 6 months. You are liable for summary dismissal. Your employer can summarily dismiss you. When you have taken it upon yourself, or rather you have entered into theft of your employer's equipment or workplace property. When you really are underperforming, but of course the underperformance has to be substantiated in terms of what was expected of you and what have you done, what have you not achieved. And so if within your administration or within your employment, the company is gradually going down, down, down. We have such other conditions such as acts of God. We normally call them, it's a French word, force majeure, which makes the employer unable to perform his side of the contract, or the employee unable to perform his side or her side of the contract. And so parties can use force majeure clauses to be able to let go of themselves from the binding clauses of the contract. And as such, with these reasons, you are not required to give the employee a chance to defend themselves, because the conviction, already there is a judgment or a sentence from the court. Force majeure, this is something that is self-explanatory. Like COVID-19, this is unprecedented. These are things that cannot be induced by the employer or the employee. When we talk about theft, I mean, if the theft is substantiated to the effect that none can see that there is one who is being framed here, then of course there's no employer who wants to stay with a thief within the employment precincts. And as such, the law allows you to summarily dismiss.
Okay. So now the concern here comes that most employers and employees enter into very fluid agreements. They're very casual. A live-in nanny that there's no contract, probably there was no even verbal agreement, apart from how much I should pay you every month. And even the amount that you're to be paid should be documented somewhere. How important is an employment contract, according to the law, in terms of protecting both the employee and the employer from these legal hurdles of unfair termination?
Actually, as I began, Fred, if you could remember, I indicated that the workplace within the country is bridled amongst numerous pieces of legislations. Little heard of is the Labour Act, and then the minimum wages. So in Kenya, the minimum wage is 710 shillings per day. And so if you pay your employee an amount less than 710 shillings, even those who are under casual labor, if you pay them a minimum, an amount less than 710 shillings per day, then you are contravening the law. The underpayment will also be required to be made up for by the courts, should the employee decide to go. But back to your question, indeed, there are very flimsy contracts that are being undertaken, and sometimes these contracts are made one-handed or one-sided. The employer decides to make a watertight contract on his side, but makes it quite easy to either extort, manipulate, or make use of the employee's services more or less for free. Services that were supposed to be paid for are now being rendered for free by the employee, courtesy of the contract. I normally advise that whether the contract contains a single line, please ensure that an advocate has a second eye on that contract to be able to advise you whether your contract is actually foolproof and covers you ostensibly. And so,
but doesn't that disadvantage me as I look for a job and I go for an interview and I'm offered a job, I'm very happy, then I'm given a contract, then I start cancelling lines in the contract and saying this one I can't do, this one is not correct. How does that work? Are we supposed to come up with this contract jointly? Because the practice has been that the contract is given to you by the employer.
Really, that is what is supposed to be. A contract for employment is an agreement between two parties. And an agreement is that what I want to offer you, my terms are agreeable to you and your terms are agreeable to me. But normally what we see is the employer giving us their terms and they come up with my terms. You understand? I don't know whether you're getting what I mean. So where I was supposed to stipulate what my terms are, the employer comes up with my own terms. Then where the employer was supposed to really subjectively or objectively give me his or her terms, the employer just notes his terms and gives me no room, no chance to speak about them. Now, being that they have a higher hand and the fact that Kenya really is facing a serious crisis of unemployment, and so the employers being spoiled for choice, take it or leave it, they have no discussion.
So when they terminate you with that kind of contract, where I had very little to say about this contract, but I signed it, can I therefore come back later and say I was unfairly terminated, yet I signed this contract?
No, if you did sign the contract, you see, even the courts are aware. There's some things we call them judicial notice. The courts are aware that before you append your signature to any document, you have or you ought to have reasonably a chance to read through. And so these are presumed facts that you actually read through the contract, you are satisfied by it, and you proceeded to execute it. And so parties are bound by their agreements, what you call in Latin the doctrine of uberrima fidei or pacta sunt servanda, meaning that agreements must be obeyed and you must be faithful to the agreement.
But there's something you said earlier that if at all there's anything that is probably illegal and contained in the contract, even if I signed
exactly,
that cannot apply.
Exactly. Okay. Anything that is illegal or unconstitutional within the contract of employment, we normally say they contravene the provisions of the law of the Republic of Kenya, of the law of the country for which this employment contract is purposed, then those sections, that is where proper agreements or contracts usually have a severability clause. A severability clause states that where any or all parts of this contract or agreement are found to be incompatible with any piece of legislation, then that individual part or clause shall be deemed as illegal, but the remaining will remain as it is. Without this severability clause, then it gives room for the court to interpret whether the entirety of the contract is unenforceable or just the very pieces that are remain enforceable.
All right, and I can see we have quite a number of questions, especially on WhatsApp. Thank you for your questions. Let's see if we can attend to some of them. Remember, 0793 267 279 is our WhatsApp number. You can send in your questions. We'll see if Wakili will have time to settle it. There's one here that I don't understand. I don't know, probably you will get it. Good morning. We have this organization that forces staff on contracts over 10 years now. It's a big company. Is it legal? Or how many times should one sign contract?
Well, depends on the stipulations of the contracts. If these contracts are supposed to subject you into casual labor, remember, continuously for a period of 1 month, then that contract is convertible to permanent and pensionable. Remember? To formal employment rather. Continuous contracts for a period of up to 6 months, then it becomes permanent and pensionable. 1 month, it is now a formal employment, from casual to formal. Then a period of 6 months, then it becomes permanent.
Even if the contractor specified that it's a casual employment for probably an extended period, like 3 or 6 months?
No, if the contract states that it is a casual employment for that period, then that contract is illegal. It is unlawful because it contravenes the provisions of the law. Yeah, so you cannot come up with a contract that contravenes the law. You're only allowed to give them this casual sort of contract for a period of 1 month.
Okay.
Beyond that, if they continue, then they are in a formal.
And I'm thinking this applies even to people in like farm workers.
Exactly.
Nannies, house managers at home.
Exactly.
Okay.
So long as you are employed. So long as you're employed.
Mtapelekwa kotini, chunga sana.
Yes, so long as you're employed.
There's another question here. Hi TV47. Very interesting topic. Can someone still take the employer to court if he or she was dismissed 3 years ago? This is someone who was terminated 3 years ago. Probably they now come to the realization that, wow, I was terminated unfairly. But can you revisit? Can you go to court and say I was fired, I was terminated unfairly 3 years ago?
Exactly. Fred, still going back to what I said, the workplace environment in Kenya is bridled among a number of laws. So here we are talking about Statute of Limitation of Actions Act. Up to what period can I go to court? Now, employment contract, surprisingly, 3 years.
Okay.
Beyond 3 years, it becomes difficult unless you ask the court to enlarge time and admit you.
So if you're still within the 3 years, you can go to court?
Yes.
If the 3 years haven't lapsed. So
exactly.
yes, I think that one is clear. So kama miaka tatu ijaisha, kimbia kotini sahi. Morning Cafe, good morning. Someone under probation is terminated by given a notice of 14 days. The termination does not indicate the reason of termination. Can such claim for discrimination?
Exactly. Actually, that was one of the reasons why this particular High Court judge gave the decision that if you pass through, because we are acting here on the doctrine of dignity of the person, the human dignity. You have to treat all of them equal. So while you give your normal employees employees on permanent, those who have been confirmed, reasons or adequate notices and reasons to be heard, you allow them time to defend themselves. Now you have leveled a charge against this person that he has underperformed. He has not met the goals. Please give him an opportunity to defend himself. And in fact, on probation, it is quite interesting that the law goes deeper to asking the employer whether the employer provided training during this period. Because it is assumed you are the one who knows what you want. So you have taken this person's academic qualification and probably work experience from elsewhere. But you know that, Fred, if probably you are in Citizen TV and then you came to TV47, you realize that although you are all anchoring or projecting some news, the underground employment world is different. You can never find employers with similar policies across board, whether they're doing the same work. So it is incumbent upon the employer to at least provide training, what they normally call the preliminary stages when they bring in the employee, orientation. You orientate your employee, tell them this, this, and this, and this, give them the work or policy handbooks, let them read through, give them the JD, have some supervisor pass them through. If you don't do this, just bring an employee, dump them there, and then after maybe a period of 1 month, give them 14 days notice, and then vaguely indicate that you have underperformed or zero performance. That employee can raise a case against you.
Interesting.
For unfair termination, actually.
Another question here by Gian from Umoja. He says he's following the show. He says on his end, he was terminated during probation and did not get enough reasons why. But he thinks it's because he was in love with his colleague, so finally Madame did a termination. This is what you had talked about earlier. Probably the law was different back then.
By then, yes.
Yeah. But this has changed.
Because you know...
But he's not even sure if that is a reason. He says probably that was a reason.
But of course there are certain things you can instinctively, sorry to say that as a lawyer though, you can instinctively see if there is a scramble for or petition for the resources within the company, where you are eyeing your boss's person the boss would really do nothing but to get rid of you. Either way.
But that would still amount to unfair termination.
Exactly, especially at this era. Previously, it would be proper termination. If the employer found out that you are having office romance. But after the High Court decision, because you see, decisions of the court really cannot be used retrogressively to cover the past.
Yes.
Otherwise, everybody who was terminated under such circumstances since independence would come up to claim. But you use the decision of the court. While the constitutional provisions can go back both horizontally and vertically, the decisions of the court begin from that time on, moving forward, unless the court specifically provides that this the effect of this judgment is with effect from such a date. But if the court doesn't do that, it is from that date of judgment moving forward.
Okay.
So if the employment probation was, he was gotten rid of or laid off on that basis of office romance, and this took place a few days or if not weeks, if not months ago, then the person can raise a claim against the employer.
Okay. But if it was sometime last year, then it was reason for termination.
Yeah, forget about that.
Right now, but what if I may use your example that you have been eyeing the same person now that it's allowed.
With the boss, yes.
And the boss also eyes the same person. And would that be reason enough to terminate someone from employment?
No. Currently, it isn't a reason. It isn't a reason in the job market because it is...
A disagreement with the boss?
A disagreement with the boss? Oh, well, there is an offense or a reason for termination known as insubordination. So it depends on how you disagree with the boss. If the disagreement was such that it amounts to insubordination as stipulated by the employment contract or as reasonably basically known, then you can be terminated.
Okay.
Insubordination.
Right.
Yes.
There's one more here. A colleague has been signing a contract for a paltry 250 shillings daily that she's been signing. Is that legal?
Okay, the signing of the contract is legal. However, the wages are below the minimum wage.
But he's on appending a signature to it.
No, if you pen a signature to what is illegal, and upon knowledge that your wages are way below, and then you proceed to accept that amount of money, still there is no justification to the employer.
Okay.
Remember what I told you before, that we are fighting against a crisis of unemployment.
Yes.
Where if I get a workplace that gives me even 100 shillings, I call it better than nothing.
Yes.
So I just take it. So the employers are taking advantage of that.
But it is an illegality.
Yes.
Okay.
Sign or...
Okay. We have Wycliffe on the line. Wycliffe, good morning. We are here with Wakili Silas Akiro. What's your question or your comment?
My question is, I'm Wycliffe Smith from Kibini.
Yes.
My question is this. We have some employees in Transoya who have been sacked by Church Natembe, the governor, and they have worked there for 10 years.
So the employees have been fired by the governor?
They have been fired by the governor, and most of them have worked for more than 10 years. Is that justice or is that right?
Were they given reasons for their termination?
The governor says there is no money, and yet other counts have never sacked people.
Okay.
Yes?
All right. Thank you, Wycliffe. Wakili, yes, there's this trouble when a new administration comes in and people have been there for about 10 years, a new governor comes in and he says, there's no money for you, maybe you are too many, go.
There are procedures you can do that, procedurally, what we call redundancy. And so you declare redundancy, you declare some positions redundant. But then when you declare these positions redundant, you don't retain them. You have to maneuver, find a way of getting rid of those positions. However, if the legal procedures set down by the law were not followed by the governor, then the governor has infringed on the employee's rights. And as such, the employees can take the county to court, and the county will be able to make up for the employment. In fact, they can either be reinstated, or if the governor's reasons are adequate and sufficient enough to sustain their termination, then the exit packs will have to be given to them.
So at what point do you decide now to go to courts as an aggrieved person that I feel I was unfairly terminated, and how can I seek redress?
Well, first you have to declare dispute, and disputes are declared through demands. Demand can either be issued by yourself or by your lawyer. Within the demand letter, you indicate your grievances and what you're demanding for. Maybe it would be reinstatement back to your position or to a higher position, depending on the duration you've been away. Number two, the demands could also indicate that, well, enough, pay me this, let's part ways. And if the dispute has been declared, you give the other party, the employer, now time to respond. If the employer does respond with reasons unsatisfactory to you, then you'd look at it in terms of, let me do a second response to the employer's response. Or, with this reason, let me terminate dispute already declared. Let's proceed to court.
Okay.
So your lawyer will file what we call a memorandum of claim or a statement of claim, along with all the documents, and state the reasons for the claim that is being prayed before the court. Then you'll have to serve the other party. Of course, the normal court procedures kicks in. That is within the purview of your lawyer.
Okay.
Yes.
We see every day in our newspapers that someone has been awarded this much money by the courts after being unfairly terminated. And I think even on the front page of one of the dailies today, someone has been given 13 million shillings. So who determines this amount? Could it be a way of making money?
Well, it could be a way of making money, but at the same time, it could be a way of mitigating the injustice. Because assuming the employer retained this person, then the court would not have the reason to award that exorbitant amount. But the employer laying off this person and still failing to make up for the exit pack as stipulated by the law, then the employer has no otherwise but to pay the exit pack as ordered by the courts. Now, when we talk about the determination assessment of this award, we are looking at leave days, like for Wycliffe. Wycliffe says they have been there for 10 years. Remember, the law allows you 21 days minimum annual leave. And this annual leave cannot be abrogated by your employer. It has to be given or compensated by some money. So take 21 days for 10 years, per year for 10 years. Make that calculation. We have leave of notice been terminated without notice. The law requires that if you're not given sufficient notice, then the employer will have to make payments in lieu of notice. And then we have compensation for unfair termination. You're not going to lose your work. Your source of income is lost. So the employer has to give you, sometimes the court order up to 6 months. Sometimes you paid your salary for 1 year. Initially, we would see some were even being given some payment for up to 96 months.
96 months.
Yes. All right. So all these things, when tabulated, then you get those, because assuming somebody was earning 1.2 per month, or was earning maybe close to $1 million, and then you do this calculation by 96 months or 12 months, it's some huge money.
Some good money there.
Yeah, sure.
Wakili Silas Akiro, thank you so much for your time as we discuss this issue of unfair termination. There are 3 things I've learned. 1, a contract is very important.
Sure.
The other things are the notice period and the reasons for termination. Those three things. Asanteni sana for those who've contributed to this conversation, including Wakili Silas Akiro. These are conversations that will definitely continue, and it can continue online. I can see on WhatsApp the messages still continue. This is where we wrap up for this conversation, but Morning Cafe still continues. After the break, we could be heading to State House for the signing of performance contracts by CSs and PSs. Do stand by for that.
Vile unavyojua watoto wengi sana hawana namna. Mimi ningependelea watoto wasome.
I'm here to stress on education. At the same time, let us actually do any kind of sport that we are doing. Sport speaks the best language to everybody.
Tunataka tutafute talents. Zile raw talents kutoka kule nyumbani mashinani mahali tuko leo.
Hizi mbio za Chepsaita, like all other sports, zinaleta watu pamoja.
We want to use this event to uplift the lives of the community.
Anafurahia hii mchezo sana. Hata sikaange naambianga watu tuende Chepsaita.
Wanafunzi wakimbie ili wakuze talanta ya mbio ama kuhimiza tena elimu.
This is the place to be. Hapa ndipo mahali wanastahili kuwa tarehe 7. Wale watoto walikimbia last year, wamekimbia mpaka wamefuka mipaka zetu za Kenya.
Hey there, friends. Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips.
Welcome back, and thank you for keeping it TV47. This is a Morning Cafe. We now want to take you straight to State House, Nairobi, for the signing of a performance contracts by cabinet secretaries and principal secretaries, of course, presided over by President William Ruto.
Our beloved nation, greater every day. Protect us and hide us in the shadow of your wings. For to whom shall we go, O Lord? You have the words of eternal life. May we serve better each day, so as to drown evil with an abundance of good. May we all always be loyal and faithful, so that success and prosperity be our portion as Kenyans. We ask all this in profound humility through our Lord Jesus Christ, who lives and reigns with you in the unity of the Holy Spirit, one God, forever and ever. Amen.
With your permission, Your Excellency, I request that we take our seats. At this point, Your Excellency, allow me to invite Honorable Felix Koskei, Chief of Staff and Head of Public Service, to take over the program and guide us with the rest of the proceedings. Welcome, sir.
Your Excellency, the President, Your Excellency, the Deputy President, Your Excellency, the Prime Cabinet Secretary, members of Parliament present, chairpersons of various parastatals, all Cabinet Secretaries, Council of Economic Advisors, chairpersons of constitutional commissions and holders of independent office, all principal secretaries, state corporations, and state corporations